All right, we are going to go ahead and start. I think there may be some people filtering in and out, but we'll go ahead and start now. So my name is Polk Wagner. I'm a professor here at Penn. Know a lot of you in the room, of course, and thank you for coming to our event on TC Heartland and future, i.e. the past, perhaps, of patent venue rules. And so what we're going to do today is I'm going to introduce our all-star panel here and give a few minutes of sort of introductory background on the TC Heartland case and sort of frame the issue, and then turn it over to my colleagues on the panel to talk more about the various issues involved in the case. We are extremely fortunate to have Judge Stark and Jim Dabney here today because both of them have extensive involvement both in patent litigation, patent venue questions, and the TC Heartland case itself. So Judge Stark was assigned to the case in Delaware for the time that it was there, Mr. Dabney was the litigant who took it to the Supreme Court and argued the case there. So I'll start first with Mr. Dabney. He is the co-head of the intellectual property practice at Hughes, Hubbard & Reed and one of the nation's foremost patent litigators. He has been litigating patents for a couple of decades now, at least, and is famous not only for TC Heartland but also the KSR case that he successfully took to the Supreme Court as well. My students will know that I think that that's exactly the wrong outcome, but we'll save that for another panel sometime later. He's a member of the American Law Institute, an adjunct professor at Cornell Law School, and we're really happy to have him here today. Judge Stark, who also many of you know in the room, is the Chief Judge of the District of Delaware and has been a judge. Let's see, you've been there since 2009 as a judge, 2007 as a magistrate judge.
2010 district judge, yes, yeah. 2007 magistrate judge. No one's counting. Yeah.
We are very proud as well that he's an adjunct professor and does a lot of work with us here at CTIC and at Penn Law. And are happy to have him here. He has been an associate at Skadden and AUSA in Delaware, Rhodes Scholar, and among the many things that he's done in his, semi-impressive defense.
Thank you.
We're really happy to have both of these terrific patent people here, as well as people who have incredible knowledge about the particular case at hand. So let me do just a little bit of background here. And we're talking about the wildly exciting issue of venue rules today, so federal venue rules. In typical federal litigation, a corporate defendant can be sued, meaning venue is appropriate in basically any jurisdiction where there is personal jurisdiction with respect to the particular civil action involved. So if you remember, those of you who are still law students or those of you who are litigating, this is a fairly broad scope of venue, and that's the general rule. And this is because in the 1391 venue statute, venue is good in any district in which the defendant, quote, resides, and residing is given a particular definition. However, since 1897, the patent law has had a different venue statute. 1400B is where it's currently codified, and it's been unchanged since 1948. And so that means we've now got sort of a general jurisdiction, general venue provision for federal civil litigation, and then a special one for patent law. Right? 1400B also uses the word resides, which is the same as 1391 does, and says that venue is good where the defendant resides or where there's acts of infringement and a regular and established place of business, so principal place of business or residing. In the Forco Glass case in 1957, the Supreme Court held that what resides means in the context of 1400B is the principal place of business only. So a more restrictive definition of what residence means than the general venue jurisdiction statute, or the venue statute of 1391, which defines residence as any judicial district in which such defendant is subject to personal jurisdiction with respect to the civil action. And so the question then in patent law for the last 30 or so years has been, does the 1391 version of residence apply, or does the 1400B residence apply? Why does this matter? Well, if you have the broader definition of residence, the general definition of residence, you're going to be able to litigate, sue people, and many more venues, in fact, almost any, essentially, if you have nationwide shipment and distribution of goods, but if you use the 1400B version, that's a much more limited set of venues than which you're going to be able to bring the lawsuit. So this really comes down to how much flexibility does a plaintiff in a patent litigation case have about choosing the place that they want to litigate the case. Do they have essentially unfettered discretion to choose a particular forum that they might choose for a variety of reasons, or are they limited to one or maybe a small handful of venues? So the issue arises in this particular case because what the Federal Circuit decided, and has decided for about 30 years, that's the 30-year reference that we have on the posters and so forth, is that the general jurisdiction, the general venue statute applies even in patent cases notwithstanding 1400B, right? And that's because of the applicability of Section 1391A says, as the Federal Circuit points out in many cases, that it shall govern the venue of all civil actions. So it has, in the view of the Federal Circuit, at least until TC Heartland, it had changed the venue rules provided in 1400B, essentially changed the definition of what residency was because of this provision and because of the changed definition. This then means that the issue gets presented in the TC Heartland case. TC Heartland makes a variety of products, including drink mixes. It's incorporated in Indiana. Principal place of business is also in Indiana. It does ship plenty of products to Delaware, so there's personal jurisdiction available in Delaware, which is where the patent litigation was filed. But TC Heartland said, we think that venue is not appropriate in Delaware because we read 1400B to be the controlling venue statute as interpreted by Forco. And because of that, we think that you need to sue us in the Southern District of Indiana only. So they moved to either dismiss the case or transfer the case to Southern District of Indiana. The district court, relying on 30 years of Federal Circuit precedent, which had held, of course, that 1391 definitions applied, not 1400B, said no transfer, denied the transfer. There was a writ of mandamus filed at the Federal Circuit, which was also denied for the same reasons, that 30 years essentially of Federal Circuit precedent had been firmly on the side of jurisdiction being okay in Delaware. So the case goes to the Supreme Court, and the Supreme Court holds that its precedent since 1897 essentially has consistently held that the patent venue statute was different and it was special, that patents had a special venue provision independent of general civil litigation, and 1400B is the place where that occurs, and that Forco is indeed the latest iteration, the latest interpretation of 1400B, and went through the question of whether the general or the specific patent venue provisions apply, and decided that in fact the specific patent venue provisions applied in a tighter venue requirement. And so they say the current version of 1391 says that the 1391 version of venue applies unless otherwise provided by law, and, as the Supreme Court points out in their TC Heartland opinion, 1400B, as interpreted by Forco, is in fact the law and has not been changed unless Congress changes it. And then they go through an analysis of whether or not the various amendments to 1391 in recent years had done anything to suggest that there was a change to the definitions of venue and residency in 1400B, and determined that there was not, and that Forco had been out there for since 1957. The definition or the language of the statute had not changed since 1948, and there was no reason to believe that Congress had any intent to do anything to change that in the more recent interpretation. So what that means then is that patent venue remains special. Residence means state of incorporation under 1400B or principal place of business. Thus, venue is good where a defendant is either incorporated or has a principal place of business, and of course, in many cases, that's the same. So here, it would be Southern District of Indiana and not, in fact, Delaware. So this has obviously been a big change in federal litigation, and we'll talk more about that in a minute. The Federal Circuit this fall followed up on TC Heartland in a petition for a writ of mandamus in the Cray case, where Judge Gilstrap of the Eastern District of Texas had analyzed the case before him under TC Heartland rules, 1400B definition, and decided that Cray, the computer company, had indeed residence in his district, notwithstanding some pretty attenuated links to that location. We can probably talk a little bit more about this, but then the Federal Circuit, when it got the writ of mandamus, said that we consider these three things to be relevant to the inquiry. One, there must be a physical place of business in the district. Two, it must be regular and established. And three, it must be the place of the defendant. One of the issues in Cray was that they had people with home offices in the district, and that was found to not be sufficient. And if any one of these three provisions is not satisfied, it is no longer a good venue under 1400B. So this represents a pretty big sea change in patent venue rules, which you can see from some of the stats. So these are stats I pulled just today from RPX, which is a company that does patent, well, they track stats among other things, but they also do patent insurance and other issues. So they're in the business of tracking these matters. I guess the axes didn't come out very well here, but you can see a pretty big, interesting thing here is this is operating company defendants, and you would think that there would be a shift towards the District of Delaware in this case, and when you talk about non-practicing entity matters, that is the case. But in operating company, it seems like people are moving away from District of Delaware, and we can talk maybe a little bit about this. It could be a crowding of the docket effect here, and more towards California, where a lot of tech companies are located. What you do see is a huge diminishment in when you look at non-practicing entities, in particular away from the Eastern District of Texas, and in particular that's being taken up, at least right now it appears, by District of Delaware as the favored place for non-practicing entities. So this is a pretty big change in the way that patent litigation is done. There's also less litigation generally, and it'd be interesting to talk about whether that's part of this issue as well. So that's sort of my general overview, and I think we'll turn it now over to Mr. Dabney to talk a little bit about his perspective as both a participant in the case as well as a patent litigator on these questions. So.
Well, thank you for that introduction. When you consider an issue like venue and you discuss whether a change has occurred, it's very much affected by the time frame that you use when you're talking about what the norm was and what is the change. Between 1897 and 1990, it was fairly clearly established that there were three places that a person could be required to defend a civil action for patent infringement. And I articulate that advisedly because where a defendant can be required to defend a suit for patent infringement is different from where a defendant can be sued. A defendant can be sued anywhere. Venue is a privilege that is waivable, and those three places were the judicial district where the defendant was domiciled. Principal place of business is not one of them and has not been in the statute, so that was one. And the domicile characterization is important because in multi-district states, it is important that you focus on domicile. The second was where a person, a corporate defendant at any rate, but a person, both had a regular and established place of business and had committed an act of infringement. Again, not principal place of business. Any regular and established place of business would do. And the third, which is often overlooked, is a judicial district where the defendant had consented to litigate. And that third one is important because in patent licensing transactions, for example, there very often are forum selection clauses, and so consent was always the third of the three venues where a person could be required to defend a civil action for patent infringement. And I use the phrase civil action for patent infringement, again, advisedly, because that language in 1400B is referring to the remedy prescribed in Title 35 for infringement of patents. And as we'll get to later, civil actions brought for judgments declaring non-infringement are outside civil actions for patent infringement and are not subject to the venue provisions of 1400B that Professor Wagner pointed out. In 1990, out of the blue, 8 years into the life of the Court of Appeals for the Federal Circuit, which was only formed in 1982, in addition to the three traditional venues between 1897 and 1990, the court announced that a person could be required to defend a civil action for patent infringement in 91 other venues, namely any place where a person could be constitutionally required to defend a civil action for alleged patent infringement, at least for corporate defendants. And that decision in 1990 was one of a substantial number of early Federal Circuit decisions which have in the last 20 years come under withering attack in the Supreme Court of the United States. The attacks really began after the court equally suddenly, equally abruptly announced in 1998 that the statutory term process included methods of doing business, which set off a whole cascade of events culminating in the American Invents Act and various other counter-reactions. So from the perspective of someone who takes a long view of what changed and what didn't change, you could say that we had an abrupt change in 1990 that was unexpected and was not accepted by everyone, but was accepted by enough people that by 2016, when that same court was asked to reconsider its view, since between 1990 and 2016, the statutory language that supported the 1990 decision had been repealed by Congress, so that if the court was of a mind to change course, it had every ability to do so. The response was unusual. In 2016, a 3-judge panel of the Federal Circuit unanimously stated that the interpretation of law that was advanced by the defendant in TC Heartland was, quote, utterly without merit or logic, end of quote. And that is known in legal circles as a bench slap. And it is something that is unusual in my experience, especially for legal positions that are subsequently adopted unanimously by the Supreme Court of the United States. So you have to ask yourself, why would the court use such harsh language in an opinion that was raising what at the time was an unresolved question? Had intervening legislative developments undermined the rationale of the 1990 decision, which had abruptly changed the view of where venue had been held. Now, I'm gonna subside in a minute, but I think there's a couple of shout-outs I need to make in order to do justice to how TC Heartland came about. You can probably imagine the conversation you have with your client that's paid you a lot of money to pursue a course of action when you're told that the Court of Appeals has said to you that your argument is utterly without merit or logic. A language which I have reason to think deterred at least one litigant to withdraw a motion for dismissal for improper venue because someone could think that pressing a motion in those circumstances could expose them to sanctions. So certainly one reason for using harsh language like that might be to have a deterrent effect. But the owner of TC Heartland, Ted Gelov, whose company name has the initials TC, people don't widely know what that initial stands for. It's not a family name. It stands for trust and credibility. And the founder of this company, who did everything right, who developed a defect-free seal so that these products sold by him would not leak, unlike the Kraft products that were sold by the plaintiff in the case, using technology that became available after relevant patents expired. He fortunately had a general counsel who was a former trial lawyer himself, who knew how the game was played and didn't lose confidence, and so they pressed forward. And one of the reasons that they were able to do so is that they'd had the tremendous good fortune, as I've told Chief Judge Stark privately, that their case was assigned to Chief Judge Stark, because petitioning for a writ of mandamus against a district judge who's hearing your case and has set a trial in your case there's that old saying, if you try to kill the king, if you shoot at the king, you'd better kill him. It is not an easy thing to do to file a petition with a writ of with an appellate court.
I could just interrupt for a second, notwithstanding the violent imagery. Because as a litigator, I had occasion to file mandamus, and I was advised of the very same thing. I just have to say the language sounds a little harsher, being the one shooting, being shot at, than the one shooting. But.
Well, I'm trying to express the point that it takes a certain amount of fortitude to take a risk like that. Not all litigants are willing to do it, but we were fully confident that Chief Judge Stark would recognize the merit in the argument and would not take offense at what we were doing, because the arguments, as we eventually demonstrated to the satisfaction of the Supreme Court, were valid arguments. But you didn't see a whole lot of imitators on this. This was something that took a lot of courage on the part of the TC Heartland Company, but we had the tremendous good fortune to have the ability to think we could do this without the district judge taking any offense at what we were doing. So. There's a lot of things that have to come together in order for a TC Heartland to happen. A lot of people ask me, how did you know to do this? Because in the months following TC Heartland, there was a period when district judges all over the country were saying that other litigants who didn't do what we had done had waived their rights. We filed this motion in 2014. Other litigants could have done the same thing, which raises the question, well, what was the law at that time? And there's a handout out there that I encourage you all to pick up about practicing patent law today requires you to make decisions even about what the law is, where you have a situation when there seems to be conflict between lower court precedent and Supreme Court precedent on an issue like this. I think in order to know to do the kind of thing that was done in TC Heartland, to do the kind of thing that was done in KSR, I return to where I started. You need to have a very long temporal perspective. We've had patent law since 1790. The Supreme Court of the United States has decided many, many, many patent decisions. The Supreme Court has its own canons of construing statutory language. The Patent Act of 1952 is full of statutory language which was lifted from the Patent Act of 1870 and had been construed and applied by the Supreme Court. And the Supreme Court is pretty protective of its institutional importance in our constitutional system. It requires politicians to act in a politically accountable manner if they're going to overrule a decision of the Supreme Court. And so to the extent that early Federal Circuit precedents would rely on very subtle language changes in statutes like the 1988 revisions to the General Venue Act to justify a revolution in patent law, the overruling of Supreme Court precedent. The important takeaway from TC Heartland is that the Supreme Court applies a much more stringent standard than the Federal Circuit has applied to questions such as, is our precedent overruled? So those who cavalierly assume that the Patent Act of 1952 impliedly overruled Supreme Court precedents that were not favored by certain members in the patent community, the message from the Supreme Court is that is a dangerous assumption to make. So with that, I will subside, and I will turn it over to Chief Judge Stark.
Okay, well, thank you. Thank you both. There's really so much that could be said about TC Heartland. I'll share a few thoughts specific to that case, and then a few thoughts more generally about where we are post TC Heartland, and then I'm sure Professor Wagner has questions. Perhaps the first thing to be said is who knew that patent venue could be made so interesting? I mean, I get invited to speak, frequently. Until about 2 years ago, no one wanted to talk to me about patent venue, and now it's pretty much all anyone wants to talk about, whether they're patent litigators or even those who aren't patent litigators. People are aware of this issue, and in part because of the impact it's had on our court, which I'll get back to in just a moment. But a few just specific thoughts about TC Heartland, because it was a case filed in the District of Delaware. You would be forgiven for not knowing that. I think a lot of patent litigators even today probably don't realize that it was a Delaware case because it was at least nominally about whether the case in front of me in Delaware should be transferred through the Southern District of Indiana. But a lot of the commentary and a lot of the interest in the case was about the Eastern District of Texas, which at the time was getting 40 to 50% of all patent cases. And so in my court, when the first motion to transfer venue or motion to dismiss for lack of proper venue came up, I don't believe there was any express reference to the Eastern District of Texas. We were asked to make a decision on the merits of the case in front of us under what we thought the law was at the time. But as the case went up on mandamus, at least the general interest and the press coverage or the blogs seemed to be mostly about Texas. And then certainly by the time the case got to the Supreme Court, not that I, unlike Mr. Dabney, read every amicus brief that was filed. Those that I read, it seemed like while the parties weren't necessarily talking about Texas themselves, certainly a lot of the amicus briefs were. In terms of the specifics of the case, so I have a somewhat unusual way of managing a lot of my patent cases as a case management issue. We have outstanding magistrate judges in the District of Delaware. I mostly work with Magistrate Judge Burke. And actually not long before you filed the TC Heartland case, I adopted new procedures which automatically referred in all of my patent cases, of course there's always exceptions, but for the most part, all motions to transfer venue to the magistrate judge. And at the time I did that, I think it was early 2014 that I came up with those new procedures. I implemented them July 1st, 2014. I didn't think that was a big deal because there, you'd get the occasional motion to transfer venue, but it was not a very common motion. Well, lo and behold, soon after I do that, this TC Heartland case comes along and was making an argument that Judge Burke and I hadn't seen before. He did his usual thorough job, probably had oral argument on it. Did you argue that?
I did.
With him? Okay. So I didn't have oral argument because Judge Burke did, and he wrote a very thorough report in which, in essence, he said, I don't agree. He did not say utterly lacks all persuasive merit or anything colorful like that. But he relied on VE holdings and followed or recommended following the Federal Circuit. And then there was an objection to that, which it is the right of the losing party to do. And that's how I got involved for the first time. And I went back and looked today. I wrote all of one paragraph on the issue, and most of that paragraph was sort of just citing VE holding. I mean, I think I had maybe one substantive sentence on the issue, which was basically, I agree with Judge Burke, who wrote a thorough and outstanding report. And that was that for the venue issue as far as I was concerned. Now, I became aware, of course, that there was a mandamus. Over the course of the next couple of years, I think we had some number of teleconferences where it would come up that, oh, by the way, there's a mandamus out there. But I was doing my best to treat this case like every other case. It was a contentious patent litigation, as best as I could tell, between competitors, and it was moving towards trial, and there was a whole lot of other litigation going on, lots of motions, trial date arguments about whether to move the trial date. It was a fairly typical contentious case between competitors. We had some recognition, of course, that the case, okay, now it's set for argument in the Federal Circuit. Okay, now we got a decision from the Federal Circuit. Oh, now they've, sought cert, but, how often do you ever see cert granted? So we just kept managing the case as an ordinary case. An interesting point came along, and I don't know if Mr. Dabby will want to comment on this, but we had a lengthy summary judgment hearing. I believe you did argue some of the motions there. And I did wonder to myself, because there were some pretty powerful summary judgment motions. At that point, if I'm not mistaken, cert had been granted, and we had a trial date. And I did wonder, as the motions were being argued, what if I buy everything TC Heartland's arguing on the merits and therefore grant summary judgment for TC Heartland on everything, it would seem to me the case is probably over. I need to enter final judgment, and the case is done. Now, what would happen to your cert petition? And would that, trust me, I would not do that unless I thought that that was the right substantive outcome, but it wouldn't necessarily be perceived that way. It might look as if I'm trying to overrule the Supreme Court, I suppose, and say, you know, aha, I can take this case away from you. As it turns out, I think you won on a number of the summary judgment motions, but I recall some part of the case did survive summary judgment. So maybe when we come back to you, you can tell me if you want to answer that or not. Another fun issue specific to that case was once the Supreme Court decision came out in May of 2017, I think we were on track for trial maybe in October of that year, but Professor Wagner quite understandably put up a slide sort of summarizing, well, essentially, of course, that case wasn't supposed to be in Delaware, so it was going to go to the Southern District of Indiana, but it's really not quite that simple, and I'm not in any way criticizing you, but what happened was the Supreme Court does what it loves to do, which is basically they spotted an issue that I think only came up in the Supreme Court, which is TC Heartland, now that we've made the law clear as to where venue is proper over domestic U.S. corporations in a patent case, it's where they reside, i.e. their place of incorporation. But the question came up, and I think only in the Supreme Court, okay, but is the defendant here, TC Heartland, a domestic U.S. corporation? And there was some reason to believe that maybe they weren't a domestic U.S. corporation. Not some reason to believe that based on the record in front of me in the trial court, but some reason based on perhaps facts outside of the district court record. But in any event, that issue got spotted by the Supreme Court, and there's a footnote in TC Heartland that does, again, what they're very good at doing, saying, we leave this issue to the lower courts to deal with. And so the Federal Circuit then did what they're very good at doing and said, we send this issue back to the District of Delaware. And pretty quickly, you all, I think, filed a renewed motion to dismiss or transfer venue based on the Supreme Court TC Heartland decision. And pretty quickly, I got a response from Kraft that said, oh, wait a minute, maybe this is not as simple as just following TC Heartland. In fact, I think they argued TC Heartland doesn't even apply to the TC Heartland case. And that was giving me a headache. And
as I recall, you were supposed to come to Japan, right? Didn't we have a couple conversations, right?
Actually, I think your trial was in October, right around the time that I was hoping to go with him to Japan, but that had no impact on anything I did. But lo and behold, and another thing to thank Mr. Dabney for was just as we were struggling to figure out, since I didn't overturn the Supreme Court the first time by granting summary judgment, maybe I can overturn them now by not following TC Heartland in the TC Heartland case. And will anybody ever understand that that might be the right decision here? Anyway, they called up and said, well, we've settled. And I was like, thank you very much. And pretty soon after that, the case was over. So that's some of my thoughts on the specific case. Just a few general points. Professor Wagner's data, I'm going to have to take a closer look at it. That's the first time in the nearly a year since TC Heartland that I've seen the District of Delaware charted in any way with anything other than a line going up. And so it may well be that if you slice it to just operating companies in whatever period you were looking at, maybe those are down. That would surprise me, but you know that could very well be right. The data that I get, admittedly, does not take out NPEs versus operating companies, but our clerk's office on almost a daily basis gets a request for what is the filing data on how many patent cases you're getting since TC Heartland and how does it compare to the same period before. And so, of course, I requested that as of today, and these numbers I think are correct. We can argue about what, if anything, they tell you, but I do think they're correct numbers. If you take, we're now 315 days post TC Heartland. You and I are probably the only two people that know that, but it's 315 days since we got the decision in the Supreme Court. If you look at the 315 days before the decision, the District of Delaware had a total of 454 patent cases filed over, just a little bit less than a year before that. In the little bit less than a year equivalent amount of time since TC Heartland, we're up to 777, which is a 71% increase. Now, I think I do have that broken down a tiny bit further, and I think it masks a little bit, which is revealed by breaking it down between the non-ANDA, the non-Hatch-Waxman cases on the one hand, and the Hatch-Waxman ANDA, the generic pharmaceutical cases. And I have my students here in the class, so they all know this already. But if you break it down that way, you see that almost all of that 71% increase is in the non-Hatch-Waxman cases. And it may be that they're almost all the NPE cases, because we don't really see NPEs in the Hatch-Waxman context. But if you look at the comparable period before TC Heartland, in the non-ANDA cases, we had 278 of those, and that has risen to 579 in the post-TC Heartland time. So that's a 108% increase. Essentially, we've seen a doubling in our non-ANDA patent cases filed, almost certainly as a direct result of TC Heartland and its narrower definition of venue. The ANDA cases have remained largely constant. They're up from 176 to 198, which is about a 12% increase, which I think may not really be an increase. That's pretty close to steady. So one would predict we'll continue to see an increase in the number of patent cases, given that so many corporations are incorporated in Delaware, and the first part of the venue statute is now limited to state of incorporation by the definition of resides. One just further thing that I would add at this point is, while there's been a real increase in the number of cases, that has not been the main thing that has increased the amount of work on our court, at least to this point. The main work that we've had generated as a result of the TC Heartland has been the motions, the renewed motions to transfer venue, and motions related to cases that had been transferred in. 2/3 of the corporations are incorporated in Delaware, or 2/3 of the biggest ones, but that leaves 1/3 who aren't, and many of those 1/3, while they didn't have the courage or whatever, the foresight to do what Mr. Dabney's client did before TC Heartland, a whole lot of them have had the courage to do that since. And so that has been a lot of litigation in trying to figure out, has the law changed? Is it new law? Did you waive it? And just even if you get past all that on the merits, is this a case where there's a regular and established place of business or not? And is it appropriate to transfer it somewhere? So in time, presumably, if we continue to double our overall number of patent cases, we'll see a lot more work as a result of just having new cases. But again, most of the new work has actually been in old cases, trying to figure out the implications of TC Heartland.
Excellent. So thanks to both of you. So I think we'll move into sort of a more general discussion at this point. I have some questions for both of you. So Mr. Dabney, so maybe talk a little more about how'd you get involved in the case? Were you looking for the venue issue and found it? Were you otherwise involved in this case and just saw, hey, this is one of the rare cases where in fact we don't have a defendant that is incorporated in Delaware, and therefore it would be a case that we could bring this challenge?
I have been raising this argument for years. This is not the first time that I've done it. There was a motion I filed in the Northern District of Illinois in 2010, which made the exact same argument without the benefit of the 2011 amendments. I got involved in this case because the company thought that the subject matter claimed in the patents did not satisfy the non-obvious subject matter condition for patentability, and KSR has made me something of a people want to talk to me about that.
An obvious choice, right?
Yeah, an obvious choice. Thank you. So that's how I got involved in it. Delaware has long had a reputation as a district that is very, very, very hard to get a venue transfer motion granted from. One of the reasons litigants like to sue in Delaware was that, not without some criticism among some mainly academics, but the Delaware district had a reputation for being very reluctant to transfer venue, to the point where that was an attraction of suing for patent infringement in Delaware. One of the things you could be relatively confident of is that if you, what is filed in Delaware generally stays there. At least that was the reputation. So at first, the notion was that seeking to transfer venue from this case would be a fool's errand. The initial focus actually was not so much on the venue issue, but on an argument that since TC Heartland had no offices in Delaware, it wasn't registered to do business in Delaware, its only contact with Delaware was that one of its Arkansas-based customers, you can probably imagine who that is, had requested certain products to be drop-shipped, FOB, Indianapolis, to its distribution center in Newark, Delaware. And if you were going to argue, does following a customer's shipping instructions at your Indiana factory, FOB, constitute purposefully availing yourself of the privileges and benefits of Delaware law? Reasonable minds could say maybe you're not. So that was one point. The other point was the VE holding decision was not alone responsible for the distortion of patent litigation that resulted in 40+% of the cases in the Eastern District of Texas. That did not become possible until a follow-on development, which didn't happen until 1994, which was to say that you could exert nationwide personal jurisdiction on the strength of a state long-arm statute over acts of infringement occurring anywhere in the country. So the principal argument when we were in front of Judge Stark, although we had preserved the venue argument for higher court treatment, was that if what you're doing is trying to circumvent the territorial limits of the patent service of process statute, and by the way, many practitioners don't know that not only is there a special venue statute for patents, there is a special service of process statute in 28 U.S.C. section 1694 that anyone who is a student of patent law should know about. Kraft could not rely on that statute because it wouldn't have authorized service of process on TC Heartland. So they relied on the Delaware long-arm statute, and the whole of the Eastern District of Texas, the whole post-VE holdings developments in venue rested on an assumption that a state could constitutionally require a non-resident defendant like TC Heartland to defend not just tortious acts in Delaware, but alleged tortious acts in Indiana and California, New Jersey, New Hampshire, and so on. And that is a very, very dubious proposition, made all the more dubious by the Bristol-Myers Squibb case that was just decided this past summer. And one of the signal ironies of the TC Heartland case is that the Hatch-Waxman parties that were my most strident opponents in the TC Heartland case were at the very same time pressing upon the Supreme Court arguments that were successful in cutting the legs out from under the jurisdictional basis of the Hatch-Waxman litigation to a certain extent. So our TC Heartland argument said the state of Delaware has no constitutional authority to require this Indiana company to account for its alleged infringement in Indianapolis. It was not set in motion in Delaware. And Magistrate Judge Burke said, well, the Federal Circuit said otherwise in 1994, and what do you want from me? I'm just going to apply from that. So it wasn't until we got to the higher court that we were focused more on venue. We'd argued it in the district court, but the actual main focus in the district court was personal jurisdiction. And I know there was something you asked me about how I got involved in it, but it was the venue argument that we didn't even make a serious 1404 argument. I mean, you know, Magistrate Judge Burke was incredibly generous with us in treating that we hadn't waived it. We did, you know, we sort of half-heartedly argued it, but what we were really trying to do was to say not that the court, that this is a proper venue and the court should exercise discretion to transfer it out, but that the court had no authority to hear the case at all.
So Judge Stark, I'm interested in so you noted that there's now a lot of work related to the various transfer motions that are now arising. Is this, so what's your sense as somebody sort of probably deeper than you'd like to be in it, is what's happened post TC Heartland from the Federal Circuit or other district courts or whatever, has it stabilized things at all? Do you feel like there's a reasonable ability to predict who's a resident in a particular location post TC Heartland, or is this going to be a multi-year exercise of lots of different cases and up and down in the Federal Circuit and back and forth until we can figure this out?
Well, a couple of caveats. Unlike TC Heartland, which is over, these issues are live in front of me as we speak, so I have to be a little more careful about what I say, but I do have some things to say. Also, all of my law clerks are sitting right in front of me, and they know as well as I do that these issues are very present and pending. So, you know, you touched on Cray, which was a very important decision. There was also the Micron decision, which was also a mandamus, and decided that, in fact, TC Heartland was a change in the law. Therefore, the venue argument was not waived in as many cases as one might have thought it was waived. So we had a split on our court. I had thought that was correct. So arguably I had invited more trouble for myself already, but that issue at least is now settled, but settled in a way that makes venue something you can argue about in a greater number of cases than would otherwise have been the case. I sometimes think that at least some of the judges on the Federal Circuit may think that they've said enough and that district courts have enough guidance and that there aren't any open issues on post-TC Heartland. That has not been my experience, however. There are very interesting questions in the Hatch-Waxman context, which I know we may get to, but at least it's enough to say a couple of district judges have looked at how TC Heartland applies in Hatch-Waxman, and we have not all reached the same conclusion. So that issue I don't see going away anytime soon. I'm aware of at least one mandamus that is pending in another one of my cases, the HTC case, which is asking whether TC Heartland applies or has impacted Supreme Court precedent on foreign corporations, and where venue is proper in a patent case with respect to foreign corporations. Presumably we'll get some guidance on that. That issue comes up a lot. A lot of defendants that we see have a domestic arm and they also have an international arm, and I've had cases, I think HTC was one of them, where we found that Delaware was not proper venue over the domestic entity post-TC Heartland, but it was for the foreign entity. So whether or not that turns out to be correct could have a real impact. So I'm not sure if are you aware of any other mandamuses that are pending?
Yes, and this goes to a point that I made. The actual holding of Forco was that resides in 1400B has the same meaning as the earlier term inhabitant. And inhabitant was deliberately chosen to be narrower than citizen and to denote the domicile of a defendant. And domicile denotes a single unique place. And this has importance in multi-district states. And there is, at least there was, there's a case called Big Commerce, that there was a petition for writ of mandamus, which raises the question whether if a corporate defendant is incorporated in a multi-district state, can it be required to defend in any of the districts in the state? My view is that under the domicile concept, which was reestablished in TC Heartland, that refers to a unique judicial district in a multi-district state. That was what inhabitant had long been understood to refer to. And so I would predict that the Federal Circuit will take that view in the Big Commerce case. That's a fairly important thing. As far as alien corporations go, I'm able to speak more freely than Chief Judge Stark has. Aliens never had venue privileges in the United States, and I predict that they still don't. The reason being that inhabitant always was the traditional protection. You were only required to sue in a district wherever you were an inhabitant, and since aliens were not inhabitant anywhere, by long-standing understanding, they were simply not subject to United States venue protections. That changed a little bit in 2011 with respect to resident individual defendants. So resident individual alien defendants may now have venue protections that they never had before. But I don't think the law with regard to alien corporate defendants has changed. And speaking of the word corporate, as Chief Judge Stark mentioned, sometimes throwaway issues in lower courts somehow take on lives of their own. One of the more humorous aspects of the TC Heartland decision is that the plaintiff in its complaint, I'm old enough to have started practice when there was no such thing as a limited liability partnership, which most law firms are now, or limited liability companies. There were only corporate entities, and so practitioners of a certain age just sort of reflexively in their complaints allege the defendant is a corporation organized and existing under the laws of Indiana, having its principal. And certain defense counsel of a certain age just reflexively say, that's right. So the pleadings in TC Heartland included an allegation that TC Heartland LLC was a corporation, and an answer which admitted that TC Heartland LLC was a corporation, and both parties were thinking of juristic persons as corporate persons, using corporate in a generic term to distinguish between natural and juristic persons and not drawing any distinction between a limited liability company, a limited partnership, a corporation, whatever more exotic juristic form might be. In the Supreme Court of the United States, I'm very proud to say that the same person who was not daunted by utterly without merit or logic, also stuck with his trial counsel to be arguing counsel in the Supreme Court, whereas Kraft brought in a Supreme Court orator who was a renowned Supreme Court argument, and from the point of view of a Supreme Court specialist, if you can get the court to not reach the merits of the case, that's a win, because that means the lower court decision stands. So the brilliant orator that Kraft hired to bring in noticed that although the issue had not been raised in the lower courts and had not been raised in the brief in opposition, you can imagine my surprise on March 1, 2017, when I get the read brief in from my opponent, and one of their main arguments is that TC Heartland is not a corporation, and I've heard reputedly a law clerk to Justice Alito has made a mention at a conversation that TC Heartland was the closest case of the 2016 term to be digged that didn't get digged. For this very reason. That means dismissed as improvidently granted because of this potential jurisdictional defect. So as Chief Justice Stark said, when we later prevailed on TC Heartland, we came back down to the trial court. Kraft argued, well, despite what we said before, you're not a corporation, and TC Heartland doesn't even apply to you, and your motion to dismiss for lack of venue should be denied, and we did end up settling the case. Courts have tended to be treating my reading of the district court cases as they do what happened in TC Heartland. They treat LLCs and corporations the same for venue purposes. They are not the same for diversity jurisdiction purposes. But they are the same for venue purposes, and I think that LLCs will be subject to the same. I'll say one last thing about this. If you read the TC Heartland oral argument, you will notice that at one point Justice Kennedy asked me, where does TC Heartland reside? And you might have thought that was sort of a trivial question, but it was actually a trick question, and the answer might come as a surprise. TC Heartland's principal place of business and headquarters are in Carmel, Indiana. But what I told Justice Kennedy was it resides in Indianapolis, Indiana. And the reason for that is that its corporate office, its public office, its registered office is in Indianapolis. And the correct view under Supreme Court precedent is that that is where a corporation is domiciled, not where its principal place of business might be. There are many Delaware corporations whose principal place of business isn't in Delaware at all, so it can't be principal place of business. So that is a point that you should be mindful of, that resides in the case of a corporation. You might think that that has an obvious answer, but we've now identified two important grades of that, both the specificity of it, and if your physical office is in a different place from where your charter says your office is, then there is a further issue to be resolved there.
And Carmel and Indianapolis, I guess, are different districts?
They're in the same district, but they're different
places.
Locations.
Right. Okay. Well, the one, coming back to your question, I foresee a lot of litigation still in this area, but one issue that I don't see arising in Delaware, since we're one district, is this question of, different
domicile.
districts, within a state.
So what is, one of the issues is both of you, I think, noted it, that sort of was in the background here, or in the foreground in some cases, was this issue of forum selection and forum shopping that had sort of developed over the last 20, 25 years in patent litigation. Certainly the TC Heartland case has altered that framework in a way that has changed it. Are we done now? Is this personal jurisdiction issue going to now arise and further upset the understanding of where corporations can be sued? What do you think is next in terms of places that people are going to litigate patents?
Well, I'll say a few things again. I think you may hear something more interesting from my friend over here, but there's been a lot of litigation about where patent cases can be filed over, I would say, the last 10 years. I've only been doing patent stuff for 10 years, and there's been a lot of it throughout. So you mentioned jurisdiction. Personal jurisdiction questions were a sort of very hot item, I guess, particularly in the Hatch-Waxman cases in the couple years leading up to TC Heartland. There was a lot of effort by some defendants to get their cases moved out of Delaware, and they principally hung their hat on lack of personal jurisdiction arguments and recent Supreme Court decisions. And so, we spent a lot of time 3-4 years ago dealing with those issues. Federal Circuit said what they said, particularly in the Accorda decision and other mandamus. And the Supreme Court didn't grant cert on that, so that seemed sort of settled. And just as that seemed settled, everything about TC Heartland and venue came up. And again, that's not entirely settled for reasons we've already outlined. But I think, I don't know that we'll ever go back to the day where there's as much concentration as we saw for a few years, with one court getting 40 to 50% of cases. We have gone from roughly 10% of all patent cases to roughly 20% of all patent cases. That's a scary enough number for me, but it's hard to see how that would go up. But still, it's a remarkable amount of concentration. You can think it's good, you can think it's bad, but my guess is as long as there is anything like the kind of concentration we see, which if we have 20% and Texas now has roughly 10%, and then the California courts and New Jersey, if you look at just 10 districts, I think we regularly get well more than half of all patent cases, probably 2/3 of them. So as long as there's that kind of concentration, and there has been for a while, I imagine there will be defendants that are unhappy with that or see some potential leverage in at least seeming to be unhappy with that. And so I would expect they'll keep finding, creative ways that may have merit to challenge that.
Well, Judge Stark mentioned a case called Accorda, and that's actually quite a very important case for people to be aware of, and there actually is an interconnection between it and TC Heartland. The Accorda case was one in which Judge Stark took the courageous step of saying that a corporation, non-resident corporation that had appointed an agent for service of process in the state of Delaware was subject to personal jurisdiction based on the service of a summons on that agent, general personal jurisdiction. And that idea is currently a very, very hot topic among federal courts, not just in the patent field, especially in the products liability area. That issue was of a special importance in my land because, in the court, because guess what defense the defendant in that case didn't raise? They didn't raise a venue defense. So that case was up on appeal. The Federal Circuit in, I think it was 2016, had issued a decision in which the majority was not willing to go as far as Judge Stark did, applying then existing Delaware state law. But Judge Malley, in concurrence, said Judge Stark was right in what he did. The majority had decided on the narrower ground that there was specific jurisdiction because my land had been threatening to sell, and therefore it didn't need to reach this broader question of whether or not it was constitutional to treat service of a summons on an agent in the state as supporting general jurisdiction. That case was pending in the Supreme Court in a beautifully written cert petition by Paul Clement, one of the most celebrated Supreme Court practitioners. And I can tell you that the TC Heartland team was very worried that the law clerks on the Supreme Court were going to look at this beautiful petition written by Paul Clement and see this other one come up, and they might want to choose one rather than the other. And so if you go back and look and see when that Accorda case was scheduled for conference in the Supreme Court, you'll see it was originally scheduled for conference on December 6, 2016. And you'll notice that the brief in opposition and craft came in on a Wednesday, and we told the Supreme Court of the United States that it should release the petition without waiting for the reply brief because we wanted to get in there. We didn't want there to be any chance that the Accorda case would come up at a conference before ours, because and so our reply brief was filed on a Monday following the Wednesday that the brief in opposition came in, because we were so eager not to be outshone by this much more famous, much more better known appellate team. And lo and behold, after that, the Accorda case was pushed to January, and our case was granted in December. And one might suppose that when the Supreme Court is given a statutory construction issue, which our case raised, and a constitutional issue, which the Accorda case raised in a case where there was a glaring procedural default brought to the surface by our petition, one might suppose that the TC Heartland petition might have contributed to something to the denial of cert in the Accorda case. But the issue that was decided by Judge Stark on this, what is the effect of registration to do business, and does that result in a waiver of defenses that would otherwise exist? Somebody is going to say that the reasoning of the Accorda case applies to venue. I haven't seen anybody do it yet. I'm a little surprised people haven't done it yet. That's one of the things that I expect to see. The other thing, since I know Judge Stark is very interested in Hatch-Waxman and teaches a class here on it, I only learned about today. Someday, the Hatch-Waxman bar, I know some of them because I've had private conversations with some of them, someday the Hatch-Waxman bar is going to rediscover that Delaware was one of the early proponents of recognizing that not just threatened parties, but patent owners were entitled to seek declaratory relief under 28 U.S.C. Section 2201 for relief that threatened actions would infringe patents. And when the Hatch-Waxman bar rediscovers that, this metaphysical issue about where does the act of infringement that is defined to occur when you mail an abbreviated new drug application to the FDA, where does that actually occur, will suddenly sort of fade away as lacking importance, because under I think of it as the Proler-Steele doctrine, P-R-O-L-E-R, Steele, there is an older body of law, pre-Federal Circuit, that provides for district courts to have authority to hear just the kind of cases that my opponents in TC Heartland were worried they wouldn't be able to bring. And so I expect to see that argument raised at some point as well.
So we have a few minutes. I have a couple more questions before we open up to further discussion. So one is, and this is sort of for both of you, how much do you think this forum selection places you litigate a patent, how much does it really matter in terms of the thinking broadly about our patent system? You know, we live in an era where it's much easier to travel. A lot of the companies that are involved in patent litigation are fairly large, well-resourced, they can move around, lawyers can move around fairly easily. Does it really matter for purposes of sort of the overall health of the patent system that we have, you know, either distributed jurisdiction or is concentrated jurisdiction better? Is it better to locate patent cases closer to major metropolitan areas, or is it better to distribute them more broadly? What do you think about those questions? So as a litigator, how much does it matter to you to be litigating in the Southern District of Indiana versus D-Del?
It matters a tremendous amount. It matters more today than it ever did. And the reason I say that is in the last 15 years, district courts around the country, notably not the District of Delaware, but many district courts around the country have been persuaded to adopt what are commonly known as special local patent rules. No district ever adopted a special local patent rule to save the court work or to save work on the part of the proponents of the rules. Special local patent rules, to my perception as one who's down in the trenches, have been adopted primarily because the proponents thought it would make those venues more attractive to plaintiffs seeking relief in those cases. And for reasons that I could get into offline with anybody, the special patent rules tend to impose asymmetrical obligations and to be ones that result in trial court procedures that, as a practical matter, are unreviewable and can make the transactions costs associated with resolving a patent dispute much higher and more risky than they otherwise would be. And so when I am called upon, as I frequently am, to comment on whether or not a venue is desirable or not, one of the most important considerations that has to be considered is whether the court is one of that increasing number that has adopted these special local patent rules. A court that lacks such rules is one that means that a person sued for infringement has many more opportunities to try to phase the case and to have threshold dispositive issues resolved out of sequence. And I'll give you an example. Another case I had in front of Judge Stark, although Delaware does not have special local patent rules, their standard order assumes that in most cases, one of the early things that happens in the case is you'll go through this exercise known as a claim construction exercise. And it is not so easy to persuade a district judge to entertain a dispositive motion for summary judgment before there has been a set of briefs and what amounts to although Chief Judge Stark chided me for suggesting this at the time, a trial, a bench trial on the meaning of words in the abstract, which I happen to think most Markman rulings and procedures relating thereto are invitations to issue dictum. But passing that aside, I managed to persuade Chief Judge Stark to permit the filing of a motion for summary judgment and to permit any questions of claim word meaning that might matter to be decided in the context of an actual dispute. So in that particular case, in the way that patent law has evolved, the patents used a term. The most important structural feature of the invention was characterized in the claim words as, get this, support element. And my telling you that, you would never guess, is this about a brassiere? What is the technology of the support element? And this particular case involved the secondary market for replacement windshield wipers. But the plaintiff in the case wanted to have a proceeding in which the only issue to be determined was what would a hypothetical person having ordinary skill in the art believe was meant by the term support element. And what the defendant wanted was a motion for summary judgment in which the court would decide, regardless of what might be the outer boundaries of this phrase, support element, what its outer Platonic perfection boundaries might be decided to be. Is the accused product embodying a support element within the meaning of this patent's disclosure and claims, which is a much narrower concrete dispute. And so when the case was called for argument on June 8th, 2015, and I suggested that, we should be focused on the concrete dispute and the case wasn't called for trial on that day, we sort of had these dueling motions going on. But that's an example of where, in most cases, what you'll have on the special local patent rules, you'll have to go through this whole claim construction exercise first. But in Delaware, you have the opportunity, which is one of its wonderful features, is that you can at least ask, without having to overcome some default rule order, that there's a more efficient way to resolve the dispute. So anyway.
I don't have anything to add except happy memories, so.
So last question, and this one is sort of more about legal change. So both of you have, both in the TC Heartland case and in other cases, have dealt with ways that lawyers can affect changes in the law, right? So Judge Stark, you are sort of there, between sort of precedent and the attorneys in front of you who you may want to encourage to offer new or innovative arguments that might affect legal change. Jim, you are talking to clients and trying to convince them that, well, in fact, although this particular argument has been held to be wholly without merit, this is nonetheless something they should utterly without merit. This is nonetheless something that should be pursued to the very end. How do you do that? Do you have advice to the many future attorneys and otherwise in the audience about how do you convince clients? How do you work with litigators who might want to do that and make the hard decisions and work work uphill in many cases against what appears at various moments to be a lost cause on a variety of levels?
Go ahead.
Right. I mean, I don't have too much to say about that, not having ever had the courage to do something like that as a litigator. But from my perspective, I think the best thing I can do as a trial court judge is to recognize what a difficult job the lawyers in front of me have, particularly in the patent cases where the law seems to always be changing, where, of course, the technology is inherently complex and not well understood. Where often there's a lot of money or other important interests at stake. And there's a lot to argue about, and they argue about a lot, and I assume, and I think this is almost always the case, that they're making reasonable decisions about what to push on and what not to push on, when to push on it, when to let something go. And helping me figure out what the best way is to use my time and energy, which is very limited. It's a limited resource, of course. And so, I don't have the time, unfortunately, to have a world full of Jim Dabneys, right? I mean, if every case is going to involve at least one motion that the Court of Appeals has already clearly said this is not the law, that's going to increase my workload substantially. On the other hand, there clearly is, and TC Heartland seems, I think, to prove that, there clearly is a role for creative litigation, for courage, for finding points in the law where you have a reasonable belief that a lower court is not following the higher court, the Supreme Court. There has to be a role for that. Some change in all sorts of areas of our law has occurred that way through that kind of litigation. And so I wouldn't want anyone to think that I'm myself or my court or most district judges are sort of inviting that or encouraging that. But on the other hand, I think we have a responsibility not to affirmatively slap it down in all instances and say, thou shalt not, waste my time ever. So hopefully, we're getting that balance close to right.
Well, no issue will reach the Supreme Court of the United States if a lower court hasn't been given the opportunity to do right. I've had many calls from many people who think they've got a great issue, and the first thing you got to look at is what do the briefs in the lower court say? And very often arguments have not been raised, and they might have been great arguments, but if you haven't raised them to the trial court, you're not going to get the Supreme Court to review the case. So the first thing you have to do is you have to, at least in patent law, you're very well advised to have a long-range perspective, because patent law did not start in 1982. Patent law started in 1790, and there is a huge, rich body of patent precedent, which the Supreme Court has gone out of its way to say again and again and again, is still good law. They say it expressly, sometimes they do it implicitly by citing to their pre-1952 Act decisions, like KSR, when deciding cases. So the first thing you need to do is to have, at least in the patent field, but this is also true in copyright and trademark, is to have a long run view. And then you have to recognize where there is conflict, because in so much law that I see practiced, what people try to do, students especially, is they try to reconcile everything that they see. Is everything that they read is legitimate? There must be a rational explanation for this. And very often there is no rational explanation. Very often what you're looking at are directly conflicting legal standards. And the dilemma you face then is, if you are in a trial court and you have a Supreme Court that says X, and you have a lower court decision that can be read as saying not X, you then get the kind of questions I got from Magistrate Judge Burke during a lengthy oral argument in which he said, has anybody ever done this before? Has any judge ever done this? No district judge likes to be the first. And you have to play small ball in the lower courts, and there was a basis on which the district court or the Court of Appeals could have ruled that intervening legislative developments meant that it was at least an open question. I wasn't asking the district court to defy the Court of Appeals for the Federal Circuit. In the Supreme Court, the gloves come off and we say V.E. Holding was wrong from the day it was decided. In the lower courts, we didn't say that. In the lower courts, we said that the V.E. Holding didn't address this specific issue. So there usually is a way that you can present your arguments in a way that is providing what Justice Holmes famously referred to as the implements of decision. You can expect the judge wants to be provided with that. And if you provide the judge with the implements of decision, you can expect that they will be fairly and impartially applied. And there's very few Federal Circuit decisions, even those that I teach in my conflicts course at Cornell, that cannot be read as harmonious with Supreme Court precedent. And so that's what you need to do in the lower courts, is to argue that properly understood, the law is not what the other side is saying.
Excellent. All right, so we are about out of time, but I think we have at least a couple of minutes for if there are questions from the audience for our panel. If not, we can retire. Anyone? Any questions? All right, well, if not, so please join me in thanking Judge Stark and Mr. Dabney for an outstanding treatment of TC Heartland. So thank you so much. So there's a reception right behind this wall right here, so I invite all of you to join us right outside for a few minutes and have some refreshments and talk further if you want.